My name is Beatriz Barragan, and I'm the Alumni Partnership Coordinator here at Cal State San Bernardino. I'll be moderating today's webinar session, Know Your Rights, Medical Leave. Before we begin, I want to take just a moment to thank you for your participation in today's webinar session. Before I introduce today's alumnus presenter, Alex Nahara, I want to take just a few moments to go over the logistics of our webinar platform. During his presentation, Alex will be sharing with you his screen, which will feature a PowerPoint presentation. As we go along, please feel free to submit your questions to Alex. We'll be stopping the presentation every few slides to check for the questions and answer your questions. To submit a question, you may use the chat box found in the GoToWebinar dashboard, which should have appeared on your screen when you logged in today's webinar session. Those questions which are not answered during today's live presentation will be answered via email. At the end of the webinar, Alex will share his contact information in case you'd like to contact him with additional questions after today's session. Also, I'll be sending to you an email with a PDF version of Alex's PowerPoint slides, which will also be posted on our CSUSB Alumni website. Technology willing, we'll also be recording today's session for archiving on our website for a later date. Alex Nahara is a 2007 CSUSB MPA graduate. He remains involved as an alumnus through the CSUSB Alumni Association Hispanic Chapter, member of the Public Administration Department Advisory Board, and as an instructor for both graduate and undergraduate courses here on campus. He is currently a Senior Human Resource Analyst and College Relations Coordinator with the Riverside County. Alex has worked for many years as a facilitator of workshops aimed at helping people become more employable. He's presented numerous workshops on resume writing, application completion, how to dress for an interview, and general interviewing skills, employee relations, and employee rights. So with that being said, I am now going to pass the screen along to Alex Nahara.
Good morning, everyone. You have to please excuse my cold. I'm fighting a cough that's been sticking with me for more than a week. I want to thank you for joining us. I believe we have 4 or 5 members that have joined the workshop. I applaud you. Leave management and leave law is not the most exciting thing to a lot of people, but it is important because it impacts our lives at some of the most critical moments in our lives, whether we're growing our family or going through a difficult time with people that we care about. Leave law and the leave management process is critical. That being said, I do want to give a little disclaimer about the workshop. You can, as an instructor here on campus, I can tell you firsthand, you can spend an extensive amount of time going over the laws as they apply to the state, to the federal government, the intricacies of how they apply to individual circumstances. So it can be quite a complicated process. This workshop is supposed to be very introductory, a 101 of sorts on some of the major legal responsibilities and rights employers and employees have. If you have additional questions beyond the scope of this workshop, I highly recommend, 1, that you check in with your employer's human resources department or their legal counsel. It really is on a case-by-case basis when it comes to leave law. So what may appear to be impactful in one situation could be very different in another. So again, the workshop, very basic 101. If you have additional questions beyond the scope here, I recommend you contact your HR or your legal advisor. This workshop is not meant to be any form of legal advice. So that's the disclaimer. Most of you, and I would have liked to have gotten to know a little bit more about you before. Let's see if I can get the screen to switch. It looks like it might be a little stuck. Here we go. Sorry about that, a little bit of technical difficulties. This workshop will be going over, I guess, like I said, some very basic information. And I only have about 55, 56 minutes to go through everything. So So I may be going a little quickly. There will be some slides that I will be passing through. As Bea mentioned, you will be able to view the audio or hear the audio at a later date, and you'll be able to view the PowerPoint presentation in the form of a PDF or on the website. So try to keep up. Understand that it's difficult for even HR professionals who have been doing this for years to learn all the details. But like I said before, follow up with the experts in your field to see how this may apply to your situation. Today, what we hope to cover are, basic introduction to family medical leave laws, FMLA, SIPRA, PDL, PFL, discussing basic employee rights, how you even become eligible for these rights, what are considered qualifying events, and how you should provide appropriate notice to your employer. That last bullet point is different according to each employer. Some employers require much more advanced notice. I would check with your HR to see what their practices are. We also hope that through the very brief workshop that we have, that you get an understanding of the laws, the rights and responsibilities you have in California, because we are very different here than in other states. And then I want to leave you with a brief set of resources where you can go and do your own research and find additional information as necessary. So why do you deal with leave, and how does this become a factor in your life? While I was preparing this presentation, I was thinking of who would be the likely audience. And in discussing with the Alumni Association, we figured that it'd be people who perhaps are going through pregnancy for the first time, or if you have just recently secured a job after a long and arduous effort at finding a job, and you find out you're pregnant. Two great situations, but it's a little stressful for people. They wonder, what does it mean now that I have this job and have this family? So we hope to answer some questions of, I just got a new job, I found out I'm pregnant, can I get fired? We will discuss how long you can be off, traditionally according to the law, and what circumstances could you lose your job, if at all. How will you pay your bills while you're off on leave? And how long can you be off of work for what's called a qualified condition? What is a qualified medical condition? And what can you do if you believe you've been discriminated against? So these are just some of the questions that we'll be discussing as we go through the 101. Let's see. So let's start off with federal and state law. Now, the Family Medical Leave Act, or FMLA as it's often known, and the California Family Rights Act, these two acts pretty much establish the parameters and the legal requirements under which you as an employee or a resident of California have certain rights and responsibilities. I always joke around when I teach this section in my HR courses that California works under the idea of anything you can do, I can do better. So the federal government came across and passed the FMLA, the Federal Family Medical Leave Act, and set out certain requirements and protections for all employees across all 50 states and territories. California decided to say, you know what, that looks great, but we're going to protect those rights and go 10 steps further. So we'll be discussing the differences, the similarities, and how they apply to you. We'll also be discussing pregnancy disability leave law, just briefly, which is specific to California. It's not something covered under the Federal Act. And we'll be briefly discussing paid family leave law. The way I like to get people to understand this is that FMLA and SIPRA, CFRA, tell you what your rights are, what's protected, how much time you have. Paid family leave law gives you a way to receive some sort of payment while you're off on a family leave. And that's something that you will want to evaluate with your individual employer. If you are a public employer, such as the County of Riverside or the state of California, there are certain exceptions or programs in place that your own employer may have, and you'll want to check in with your HR to see what's in place for you. But for most of the private sector employers and some public sector employers, employees, you use the PFL to help cover or receive some sort of financial benefit while you're off attending to a medical emergency. Pregnancy disability leave, PDL, is, again, something very unique to California and is a means by which you can receive additional benefits as well, specifically for women before, during, and during the pregnancy process. It does not apply to men, and we'll get into that in a second. So what's the spirit of the laws? In essence, all of these regulations, the purpose is to provide an opportunity for employees to balance their work and family life by taking reasonable, unpaid leave for specific reasons, without the fear of having to choose between their job and their family. That's the whole idea behind these laws. And the key term here is that both FMLA and SIPRA, as we call it, is about unpaid leave. It doesn't guarantee you payment, not those two laws, but they do say that if you qualify under those, that you have a right to take time off to be for these qualifying conditions and not be afraid of losing your job. But you do have to qualify for them. FMLA and SIPRA. They offer you 12 work weeks or 12 work weeks of unpaid leave during a 12-month period for most qualifying events. So what does that mean? Without getting into too many specifics, it means that if you qualify under FMLA, and the thing's kind of moving on its own, and here I have listed the county, you are entitled to 12 weeks of unpaid leave at that time. The county, Riverside County for example, we calculate that on what's called a rolling period, 12-month rolling basis. So if I needed to go off today for an FMLA or SIPRA qualifying event, my employer would calculate from the effective date of my leave request back 12 months to see if I have worked enough hours, if I have utilized any of the FMLA or SIPRA leave, and what I qualify for, if anything at all. Now, that's the county practice. Most employers utilize that, but again, you'll want to check with your employer to see how they calculate that. I included an additional slide on the service member FMLA coverage. This allows an individual, again, on unpaid leave, up to 26 work weeks of leave during a single 12-month period to care for a seriously injured, ill family member who is a covered service military member. Military care leave must be measured forward from the date the leave starts. So if you can recall, when we were talking about just regular FMLA for someone like myself, the leave was calculated, whether I qualified for it or not, backwards 12 months from the date of the needed request. For military care leave, very different. You calculate it moving forward. So I've often had employees say, I took FMLA for myself this past year, used all of my time, and now my spouse has returned from Afghanistan, from service. They were an active member, and they're suffering through some treatments that we need to take. Can I or do I have any protected time for them? One specific federal provision is this one that allows you to take additional time for the care of your family member suffering through these service needs. This can get really tricky. Even for those of us in HR who do and handle this on a regular basis, you really have to calculate that on a case-by-case basis. and sit down with your HR representative or legal counsel and figure out what you have available to you. If you believe that you qualify under either of these provisions of FMLA, I would go and seek additional assistance. I know that we've had many people who think they only have one or the other option, and it turns out that they have more protected time than they expected. So what protection does FMLA and SIPRA provide you? It protects against unlawful discharge, discrimination, or retaliation for employees exercising their rights to take a leave. So if you have taken and are qualified for FMLA or SIPRA, and your HR will let you know if you are, an employer cannot utilize that time against you in a disciplinary fashion or retaliate against you for exercising that time. So if you take FMLA and you take all 12 weeks of unpaid leave, an employer can't say you were gone for 12 weeks using your FMLA time and you had a negative impact on our business operations, we're going to let you go. That's a big no-no. And while I'm simplifying it there, the spirit is to allow you, again, to balance your life and personal and work needs, knowing that you won't lose your job. And you'll have to forgive me a little bit with some of the erratic movement on the slide. It seems to be moving timed on its own, so I may be moving back and forth on some of the bullet points. As the second bullet point shows there, your FMLA, SIPRA, or pregnancy disability leave time cannot be used against an employee in their performance evaluation. So if you qualify under these provisions and an employer, once you return, comes back and says, you know, you really weren't performing at the level that you should be, and they include, as part of your reason for not performing, the time that you were out under protected leave, that is a violation of the law, and that can create some serious problems. My hope and guess is that your HR will stop that from even going through, but if you believe that this may have happened, you'll want to discuss this issue with your HR department and find out what's going on. But as a law, that time is not to be used against you. FMLA and SIPRA also allow you to maintain your existing level of coverage under a group health plan. So when we have individuals at the county that go off for 3 weeks or 12 weeks or longer, depending on the combination of their leave needs, we make sure that we maintain their health care coverage under our county plan. While they are responsible to pay the premiums for it, as they normally would, we are required by law to continue to offer that to them. So if an employer should tell you, and when this happens, it's typically not with large employers or public employers, but with mom and pop shops, some employers may pull the provision that, well, we're going to give you the time, but we're going to cut your medical. And you need to be aware that that is a very serious violation, because that is a form of coercion. If you need to go off for a qualified medical condition and you qualify under FMLA or SIPRA, and they tell you, well, go off, but we're not going to give you medical coverage to treat the issue, that obviously is going to have an impact on your decision to go out. And the regulations and laws are there to prevent that from happening. Other basic rights is that when you return from these leaves, it is to restore you to the same or equivalent comparable job. That, sometimes people think, well, that means I get to come back to the same position and the same desk at the same location, no questions asked. That's not necessarily the case. While obviously employers will try to minimize disruption to an employee and their work assignment, if you have an employer such as the County of Riverside, where we span, you know, thousands and thousands of square miles, we sometimes have business needs that may require us to move an individual from one office location to another. But we do keep them in the same or equivalent comparable position. We cannot demote them, and we cannot give them a lower paying position simply because they were off on leave. Some people like to think that if you're off on leave, that protects you from layoffs. That's not true, and that's a separate issue all in its entirety. But what this law basically says is, if I go off, I should come back to a comparable or similar job. It may be in a different location, it may be doing a different set of duties, but the classification and the nature of the job stays the same. It does not protect against layoffs. Many people think if I'm on FMLA SIPRA, I cannot get laid off. That's not the case. If there are business needs and the department or the organization indicates that this classification or these groups of individuals as a whole have to be laid off and they justify the plan and it gets approved, you can still be laid off while on leave. What can't be done is that you get laid off because you're on leave. And you know that obviously you need to evaluate that. If you have concerns about that, or if you feel that may have happened, you'd want to talk to your HR. But you know the general idea is it does not automatically protect you from layoffs if they're done according to the requirements of the MOU and the state laws. So how do you get eligible for some of these benefits? We've gone over the spirit of it. We've gone over what it's intended to do. And again, there's a lot more to it. I'm giving you very, very basic information here and trying to condense it into less than an hour. How do you even qualify for this? How do you qualify for FMLA and SIPRA? Well, the first thing is an employee must be employed for at least 12 months within the past 7 years as of the date the leave commences. So they can be 12 consecutive months. They may not be 12 consecutive months, but they have to have been employed 12 months within the past 7 years. That seems a little strange, but that was really built in, that provision, for those employees that are seasonal, crossing guards, park rangers, people who don't work a full 12 months all the time. In addition to that, an employee must have worked, again, I apologize for that, employee must have worked at least 1,250 hours during a 12-month period immediately preceding leave. So again, if you take me as an example and I have to go off on work for a protected reason effective tomorrow, and they calculate backwards the last 12 months, I have to have worked 1,250 hours in a paid status of some sort. 1,250 hours is a little bit more than half a year. Your average work year, 40 hours a week, is approximately 2,080. So the law says in order to qualify, you must have worked 12 months within the past 7 years, and within the last 12 months, you should have worked 1,250 hours. Worked 1,250 hours, or been in a paid status. So if you have that, then you meet the qualifications. I'll try to skip. So we're going to go over this quiz. You can take it afterward. We're going to move on to what is considered a qualifying event. So we know now that you have FMLA and SIPRA as your protection, generally by the federal government and the state. We know that you are under those laws. You should work 1,250 hours in the last year, 12 months, and you have to have worked at least 12 months for the same employer in the last 7 years. But what kind of incident or what kind of condition qualifies you to even exercise that law? Well, we call it a serious health condition of employee. For those of you familiar with workers' comp or occupational injury, that can be considered a qualifying event. It also can be a non-occupational injury. So if I have a skiing accident, and it's on my own time, it's not work-related, but it meets the subsequent rules that I'm about to discuss, it still may and should qualify under FMLA. So you also can qualify for FMLA if it's a serious health condition for a family member. Now, under FMLA, remember, this is a federal law. What they call and consider a family member is a little different than what they call and consider a family member or a qualified family member in California. We tend to be a little bit more inclusive with our state laws than the federal government is. Spouses, so serious health condition for yourself or a serious health condition for a family member. And a family member is defined as a spouse, son or daughter, employee's parents, or person who stood in local parentis to an employee. The law currently in the works is to add and clarify these categories. And this actually brings up an excellent point. The tricky thing about leave, in addition to the fact that there are many facets to it, and that it is a case-by-case basis, the laws are constantly evolving. Just this past December 30th, the state of California had additional changes to its laws that went into effect that affected the pregnancy disability leave and the accommodation needs that we need to offer. So that's the other tricky thing about leave, and this is why you do have to talk to your HR or legal counsel. Just when you think you've figured out what you qualify and what you don't, the laws evolve, the laws change. So you really want to make sure you go and get the most current information possible. What else is a qualifying event under FMLA? Qualifying exigency. Typically, if you have a significant other or spouse in military service and they get their orders to leave, they usually don't give you, or they don't always give you, a lot of notice to let you know that they'll be deploying or reassigned or whatnot. So if you have to, and if you think about it, if you're with a significant other, parent, or the child, if you fathered and had children together, now you have to figure out who's going to take the child to daycare. How are we going to work out the logistics of this sudden deployment? Under this qualifying leave, you're able to take some time to kind of put your house in order in preparation for your military member leaving the house. It is something that most people don't come across in their day-to-day life, but if you have someone in the armed service or you yourself have been involved in this, you may be more familiar. I, again, recommend you talk to your HR and discuss what's qualifying exigency and how it affects you and when you can utilize that and what options you have. Another qualifying condition under FMLA is serious injury or illness to a covered service member. Again, this goes to the military. Remember, we were talking about that 26-week period that they get. If a member comes back from a tour of duty or active duty and they're suffering from post-traumatic stress disorder and they're having to go through therapy, or they're having actual physical therapy that needs to get done to rehabilitate limb loss or other factors, that is considered part of that qualifying FMLA period or condition. And because it's military-based, you would get the 26-week option versus just simply the 12-week option. So again, talk to your HR and find out what your specific circumstances say and which leave is the best option for you. And I'm sure they'll give you they'll steer you in the right direction. Other qualifying events: birth of son or daughter, to care for and bond with the newborn child. Now, if you notice, this is for FMLA and SIPRA, so this is for both the federal and state. Placement, sorry about that, placement of a child for foster care or adoption, also a qualifying event. Another reason why you may be able to exercise one or both of these protected leave options. So I wanted to do, given all the discussion we just had, a brief comparison of the two, FMLA versus SIPRA. So FMLA is for a serious health condition of the self, of you, of your employee, of your parents, your child, your spouse. SIPRA, which is the state law, is the serious health condition of yourself, of the employee's parent, of a child, of a spouse, In addition, California, under SIPRA protection only, includes registered domestic partners and the child of a registered domestic partner. So if you went to another state outside of California, you would have the protections FMLA provides you, but you would not necessarily have the protections offered under SIPRA for a registered domestic partner. You'd have to study the laws and requirements of that state and see what's applying to you. I also want to provide just the bulleted information on the FMLA military caregiver. For that one, it's for serious illness or injury of the employee's parent, son, daughter, spouse, or next of kin for those in active service. Remember, this is only for military, those in active service. So it can be for your parent, it can be for the son and daughter, it can be for the spouse, it can be for the next of kin, and that would enable you to exercise the military caregiver FMLA option. Again, you'll be able to view this later on, and I believe you'll be able to hear this recording at a later point as well. And as always, you want to check with your HR or your legal counsel. So we know generally the spirit of the law, or the laws. We know the protections that they offer you. We understand generally how you qualify. It needs to be a serious health condition. You know that you need to work 12 months within 7 years, and you need to work at least 1,250 hours within the last 12 months. We just went over who's covered. Now we're going to talk about what is considered a serious health condition. The first and easiest way to qualify something as a serious health condition is inpatient care. So in other words, if you go to the hospital and have to remain at the hospital for treatment overnight or whatnot, that's inpatient care. Another way to qualify, another way something is considered a serious health condition is if you're receiving continuing treatment by a healthcare provider, which includes one or more of the following. Now, so, you're either in the hospital and you had to stay overnight, or you go home but you are receiving ongoing treatment. And it must include the following. There must be a period of incapacity of more than 3 full consecutive calendar days. That also involves in-person treatment at least once within 7 days of first day of incapacity, and either a regimen of continuing treatment initiated by your healthcare provider during the first treatment, or a second in-person visit for treatment, the necessity of which is determined by the healthcare provider within 30 days of the first day of incapacity. So let me try to put that in layperson's terms. So either you're in the hospital overnight for an appendix that erupts and you need to have it removed, or perhaps you have that skiing accident and you go to the emergency room and they fix your broken leg, put a cast on, but you go home. But you are put off work because of the broken leg for 3 days or more. So now we're in the second scenario. If you look at the bullet point that says in-person treatment at least once within 7 days of first incapacity, if you break that leg, your doctor's probably going to want you to check in within the week to see how the leg is healing, how things are going, to make sure everything's starting to set appropriately. Then after that follow-up visit, the healthcare provider will say, all right, we either need you to continue coming back every 2 weeks so we can change the cast, or come back in a month so we can remove it because you should be healed by that point. So while there are many other ways that may play itself out, that's generally what we're looking at. You either have that appendix surgery and you have to stay overnight and you're in there for a couple of days, or you broke your leg in a skiing accident or skateboarding or whatever you're doing, and you had to go get that initial treatment. You went home, came back within a week for additional checkup, just a simple checkup, and the doctor has said, we're going to continue looking at how you're progressing over the period of the next 30 days. Typically, you get a doctor's note for that. So when we see that, we consider that a qualifying medical condition. Now, if you're not sure whether your circumstances might fit under that, again, talk to your HR. One of the things that few people realize is that we in HR went into it at some point, or if not, stay in it, because we love to help people and answer these questions and explain these things as much as possible. So if you have these questions, go talk to your representative and make sure that you include them in the process, because it may be, you may have a variety of options that you want to look into. Let's see, continuing treatment. So we talked about that broken leg. What is considered continuing treatment? Usually something provided by a healthcare provider, a doctor, nurse practitioner, psychiatrist, depending on the condition, that includes one of the following: any period of incapacity due to a chronic condition. So if let's say I go to the doctor and I have I break that leg, and I in that skiing accident, and it happened because I went into an unconscious state. They fix my leg, and they determine that I'm healed after a month. But in the process of figuring out why I blanked out in my skiing trip, it turns out that I, suffer from convulsions or epilepsy. That's a chronic and long-term condition. That's not something that is cured, quote unquote, with a couple of treatments. If it's a chronic condition like that, you have to or usually receive treatment for that on an ongoing basis. It may not be every month, it may not even be every year, but it's the kind of thing that requires ongoing treatment. When we try to explain that to people, we often discuss things like diabetes, epilepsy, asthma. That's considered a medical condition that qualifies, that's ongoing, and they would qualify for FMLA and SIPRA. As it states in the smaller bullet point, you must be treated by a healthcare provider at least twice a year for that condition. But treatment and what we mean by that tends to be a little subjective. Typically, it means you've got to have some interaction with a healthcare provider for the condition. The other kind of continuing treatment is a period of incapacity in which permanent or long-term treatment is required due to a condition for which treatment may not be effective. There was a time where they would only qualify conditions that could be treated and that would ultimately result in a cure or mitigation. But there are some conditions where even though you're receiving treatment, there isn't necessarily a cure. And I give some examples there: Alzheimer's, severe stroke, terminal stages of diseases such as cancer. There was a question as to whether, at one point, early on, not until recently, whether cancer patients should be receiving FMLA protection. Now we look back on that and we think, of course they should. But that provision was built into the law to protect individuals whose condition may not improve with treatment, but should still benefit from the law. So that's very quickly, very briefly, FMLA and SIPRA. Those two are what we call, they can run concurrently. So you can have FMLA, the federal time, and the state time run at the same time. Some people like to think, well, I get 12 weeks of FMLA, and then I get 12 weeks of SIPRA. So in truth, I get 24 weeks there. In most cases, that does not happen. There are some circumstances where that timeline can get a little interesting, but that's, again, a case-by-case basis. And I would recommend that you talk to your HR representatives or your legal counsel and find out what time you have available, if you're qualified, how much time you're protected, and what benefits and options, short-term disability, et cetera, is offered either through your MOU or through the state. So I'm going to move now, transition very quickly into pregnancy disability law, leave law. This is for individuals who, females in particular, who are pregnant. And so, gentlemen, unless you're able to give birth, and most of us aren't, last I checked, this law doesn't apply to us. But if you have a sister, a daughter, a wife, they may at one point benefit from this law. When I teach this class, I've had a few people, a couple of gentlemen, raise the question of why even have this law if it's not beneficial to everyone. And the truth of the matter is when it comes to leave law, it's about the moments in our lives that are important and impactful. So while gentlemen may not directly benefit from this law, it is a tangential benefit for us. So I always say, you know, you want those who are going through a pregnant state to have the time protection to be able to take care of a child. So what does PDL offer? It covers any female employee regardless of the length of employment or number of hours worked. That is significant because when we talked about FMLA and we talked about SIPRA, you had to have worked 12 months in the last 7 years. You had to have worked 1,250 hours in the last 12 months to qualify. But with PDL, and this is only for the state of California, if you are a female who is hired and you become pregnant, or you are pregnant when you become hired, regardless of it's day one, hour one of your employment, you are protected by this law. That's for those of you who are concerned that you've just got your job, you've finally got yourself situated, and you become pregnant, you're concerned about losing your job. This law is for you. It covers employees' own disability, so female employees' own disability due to pregnancy, childbirth, and pregnancy-related conditions, including prenatal care and severe morning sickness. This is one of those laws that I was telling you was revised recently on December 30th of 2012, and it now also includes things such as postpartum depression and medical treatment for that. And there are several other provisions that have changed. I included at the end of this PowerPoint a link to a couple of different resources where you can read up on those changes yourself. If you're an HR nerd or a law nerd, you'll love it, but it is some dense reading. What else does PDL provide you? It provides you up to 4 months of unpaid leave. So pregnancy disability leave is unpaid leave. Now, if you wish to get paid, there may be a couple of options that you have to cover you. Your employer, if you're a public employer, may have a third-party long-term or short-term disability insurance plan. You'll want to see what's available, how you qualify, what needs to be done in order to get that, and your HR people have that information. If you're a private employer, most private employers and private employees pay into state disability insurance, get that taken out of your check. So when you're paying into that out of every check and you become disabled for pregnancy reasons, you're able to apply for a state disability and receive payment, at least some form of payment, during that time. But this law, what it's about, is about giving you time to take care of your child. And you need to realize that it's 4 months of unpaid leave. It is for, again, the pregnancy, childbirth, pregnancy-related conditions. So if you are so sick with morning sickness that you can't come into work, that's qualified and covered under PDL. If your doctor's appointments for prenatal care that become more frequent as you get later on in pregnancy, that's covered under PDL as well. Just like the FMLA SIPRA, it provides job protection. It does not provide for continuation of benefits coverage. So that's something that you'll have to discuss with your HR staff and see what options you have at that point. But you know, it's a different law, and it's an interesting and important one in that it doesn't require the 1,250 hours or the 12 months in the 7 years It is really to protect women and protect against the discrimination that had been occurring previously in the workforce. Now, paid family leave law. For what I call is the NGO, the non-government organization, also known as disability insurance. Do not confuse paid family leave law with pregnancy disability leave law. They're very similar, but they're different. PFL, paid family leave, though who's eligible for that? That's any EE covered by state disability. It's care for a seriously ill child, spouse, parent, or registered domestic partner. Bond with, it's also for those who are wanting to bond with a new child or the child of an employee, or the child of the spouse or registered domestic partner. Now you realize that the pregnancy disability leave was for the woman. This would be for the partner of the pregnant individual, be it registered domestic or your traditional relationship. It enables you to go and spend time to bond with that child. As you can see, it's bonding with for child adoption or foster care placement. It applies to all businesses regardless of size. Unlike FMLA or SIPRA, no specific month or work hour requirement is necessary to receive the benefit, to receive the financial benefit. It is based on wages earned in the 5 to 18 months prior to insurance claim. So let's say I need to file because I've just adopted a child and we're going to go out and I need to go out tomorrow. When it's being qualified, if you're being paid by a state disability, they will calculate it based on the 5 to 18 months prior to when I made the claim or the request for the insurance coverage. So in my case, they would look at, let's see, we're in January, I'd be going back to August, July, and they'd start from that point and go back 18 months, or go back up to an additional 13 months from there, and calculate what my qualifying income was, and then give me my insurance claim based on that. The claim must be filed within 12 months of birth or adoption. So you can't claim and request this before the birth or adoption occurs, obviously, and you can't claim it in the second or third year after the child's been born or adopted. So that is a specific limitation that you need to be aware of. Let me see. I want to put it there. Okay. Well, how are we on time? Let's see. We have about 11 minutes. I wanted to provide a little comparison of FMLA, SIPRA, and PDL. Little quick visual chart. FMLA, as you can see, the first column tells you the type of leave covered, and it tells you which laws apply to it. So if it's a pregnancy-related type of condition, includes disability from childbirth, an employer typically can apply FMLA and pregnancy disability leave. If it is for bonding with a child, whether through adoption, your own birth, or whatnot, then you can use FMLA or SIPRA if they're available, but not pregnancy disability leave because you're not disabled, so it's for bonding purposes. If it's for other serious health conditions outside of pregnancy, then you use FMLA or SIPRA. So if it's a non-pregnancy related injury or health condition, you obviously can't use pregnancy disability leave. Skip through here. So we've kind of discussed briefly over the rights, who's covered, what's eligible, what's a qualifying condition. Again, this is very quick. I recommend you contact your HR to get additional information. But one thing you need to know is that there are some provisions as to how you should communicate the information to your employer. Ideally, and we always say this to our employees, an employee may give notice orally or in writing. Most employers, in fact almost all the ones I know, have an actual form that they prefer for you to submit. Employees must provide sufficient information for an employer to reasonably determine whether FMLA may apply. And same thing for SIPRA. So, you know, we talked about what's a qualifying condition. We talked about what's a serious health condition, how that meets the criteria. Calling in sick and just saying I'm not feeling well is not enough to say you qualify for FMLA. We need something documented that addresses some of the things that we discussed earlier in the presentation in terms of qualification requirements. So just calling in your employer and saying, hey, I'm sick today, and doing that for a week or two doesn't mean you have FMLA. Now you'll need to read your MOU and talk to your HR people, but if you want to use FMLA time, you need to provide us with the right documentation, and we need to be able to verify it. Typically, a certification from a healthcare provider is required. For subsequent requests for the same FMLA qualifying condition, employee must specifically reference qualifying reason or state FMLA leave. So if, and there are different types of FMLA, there's continuous and intermittent. And we didn't go into great detail into that here, but a continuous FMLA, for example, is you take the full, a block of time dedicated to FMLA. It could be 2 weeks or more. It could be you take the full 3 months, 12 weeks. Some employees don't need a full 12 weeks off. They maybe have a medical condition that only requires that they take off 3 hours a week every week. Let's say you're going for dialysis and you need to go and get your dialysis treatment every week. Instead of taking 12 weeks off and using all of your time, you can request what they call intermittent FMLA, and basically, if you qualify, just take enough time that you need to cover that treatment for that qualifying condition. So those individuals would go to work and just take that necessary qualified time for the treatment that they require. Again, talk to your HR and understand whether you need continuous or intermittent FMLA. And here's where we start talking about how it can be taken. You can take it as continuous leave, or you can take it as intermittent or reduced work schedule. So if an employee requires intermittent leave, they must confer with the employer so as to minimize disruption to the employer's operations. So, you know, you can't just say, hey, I qualify for FMLA, I'm going to take intermittent, and this is the schedule we're taking. You want to discuss that with your employer and figure out what's the best solution to see how not to impact the operations. When calling for intermittent leave, an employee, you must follow required call-in procedures, and you must notify supervisors that that the leave is for FMLA purposes. You have no idea how many employees I have to deal with who submitted all the initial paperwork, get qualified for intermittent FMLA, call off sick because maybe they're suffering from a migraine that day or their asthma has flared up, and do not let the first of all, they don't call in some instances, or if they call in, they just say, I'm not coming into work today. And they don't specify that it's for an FMLA, for the FMLA protected reason. When that happens, we don't automatically code that time. Now, I would talk to your HR staff and see what they do and how they do it at your employer, but you as an employee, in order to exercise your right, need to notify your supervisor in the proper chain of command, and you need to let them know that if you're off that day, it is for that FMLA protected reason. One reason that matters is that, for example, at the county, we have this thing called a medical certification program. So if an employee is missing a lot of work for a variety of reasons, and we have reason to suspect that they're abusing their sick time, we put them on a program where they need to bring us a doctor's note every single time they go out on an absence. If the employee lets us know that it's, when they call in sick, that it's for an FMLA qualifying reason, we may not require that note, depending on a couple of circumstances. But it, in essence, helps provide you some protection. Otherwise, all those absences, if they're not coded and identified as FMLA, may be used against you as a performance issue. And, you know, it's something that, if it's qualifying and protected, you shouldn't be dinged for that. Can also be taken for bonding leave. It must be taken in increments of at least 2 weeks. Generally, I've seen employers make that adjustment where that's not a requirement. The only thing employers need to do at that point is make sure that they apply it consistently to all individuals within their organization. So we're pretty much at the hour here. What we want, you know, in terms of designating leave, so let's say you submitted all the paperwork, you believe you qualify, you got the doctor's note, and you submit everything that we need to the employer, to HR, for example. The employer must give written designation that the leave qualifies or not within 5 business days after acquiring enough information to determine if it qualifies. So you just giving me a note, or you just telling me that you have a medical condition, but not providing me with a medical note to substantiate that, doesn't mean you've completed your responsibilities. You need to give me all the forms and all the documentation. Once I have all of that, then as an employer, I have 5 days to respond to you. An employer must give written designation at any later time, as long as the employee is not harmed. So if it does take longer than 5 business days, I can take a little longer, but it can't be done in such a way to harm you. It's no longer any need to provisionally designate someone. We used to do that as a practice in the past. You know, most employers don't do that now. It is the employer's prerogative to designate qualifying leave, regardless of the employee's preference. So, and I would talk to your HR. That is an employer-to-employer decision. I know what the county does. I know what other employers I've worked with have done. If you'll want to check with your employer to see what their practice is in that respect. But basically, what that bullet point says is, if you have a qualifying condition, we have reason to believe that it's FMLA qualifies, and the MOU, your labor agreement, doesn't speak to the situation, we may designate the leave as FMLA, usually done in conjunction with the employee. We don't try to surprise them. The last thing that you need to know before we separate is what your supervisor's responsibilities generally should be. You know, as a supervisor, your supervisor should, or your HR staff, should advise you of what you're eligible for and for what your leave protection rights are. That's why you need to check in with them, because they'll be able to be your greatest resource. You also want to refer the, you also want to make sure that the supervisor, when they find out about a potential leave case, is referring you to the right HR or leave person for the paperwork. So if you let your supervisor know that you maybe have a medical condition that qualifies, the supervisor should be putting you in contact with HR, or at least giving you the paperwork that you need to get the process going. The final page here is a very simple resource page. It goes over FMLA, where you can get more information than that. That's with the Department of Labor. For SIPRA information, you can go to the Department of Fair Employment and Housing for California. For PDL information, you can go to that website. And for the paid family leave information, you can go to EDD and the website located there. I just want to take a moment to thank those of you who stuck around through the presentation. It was a very quick presentation over covering a very large amount of information. I cannot stress enough that if you have concerns about this, or if you feel that you may qualify for some of these conditions, you will want to contact your HR or your legal counsel and see what options you have available. Other than that, I thank you for joining us, and if you have any questions, contact the right people, and you're welcome to give me a call as well. Thank you very much. Have a great afternoon.
Thank you, Alex. As mentioned, Alex has agreed to take any questions that you might have following up today's webinar, or as he's recommended, to contact your HR people if you have any follow-up questions. So please feel free to contact him. His contact information is on the screen right now. Again, thank you all who participated in today's webinar. As you exit the webinar, please take a few moments to complete a brief survey that will appear on your screen. Your feedback is critical in helping us to grow and expand our programming to meet the needs of our students and alumni. We hope you found the experience valuable and that you'll consider attending future CSUSB alumni events. And as always, you are in good company. Again, thank you all.